Jennifer Dutton and Mark Johnson.
All right, we are here for docket sounding. We are prepared to begin our jury selection this coming Monday. We have jurors scheduled to arrive at the courthouse at 8:30 Monday morning, as well as Tuesday, Wednesday, and Thursday of next week. I did receive a motion to continue the trial that was filed by the defense, so I know that we need to address that motion. Are there any other motions that we need to address this afternoon?
No, Your Honor.
No, Your Honor, we have spoken to the state about some other issues last week and resolved most of them.
Okay. All right, well, let's take up your motion to continue, counsel. I'll hear from you at this time.
Your Honor, the state had filed as the court is aware, a motion to impanel 6 on January
Can
13th.
you do me a favor and move that microphone so that I can hear you?
The state had filed a motion to impanel 6 jurors on the 13th, and the court had granted that motion on January 20th, which started a clock of 10 days for defense counsel. On the 30th, that was this Monday, we filed a writ with the 5th District Court of Appeal. The nature of the writ, the 5th District Court of Appeal had discretion to accept or reject that writ of certiorari as filed. They accepted it, and the following day asked the state, specifically Attorney General, to file a response to that writ within 20 days, and allowing defense counsel 10 days from service of the response to file a reply. So with all that in mind, Your Honor, defense counsel is asking for continuance because the nature of the writ before the 5th District Court of Appeal will impact the jury selection of this case, and jury selection, as the court is aware, is a significant and reversible issue should the DCA rule in our favor. So we're asking the court to stay the proceeding between the state of Florida versus Ethan Fucci as set for Monday, and allow the 5th District Court of Appeal to continue this process to review the writ as filed and give the Attorney General opportunity to respond.
All right, Steve?
Your Honor, we would object to any continuance in this case. The issue is well preserved. It is an issue that could be taken up on appeal post-verdict. In speaking with the Attorney General's office, I was informed that if the matter was deemed an emergency or necessary, at the time they asked the state to respond, they would issue what's called an order to show cause and staying the proceedings at the trial level. They did not choose to do that, so we are under no obligation to stop proceedings now. As Your Honor knows, this is the decision in this case, and Your Honor's decision is well-founded in over 50 years of case law in the state of Florida, supported by the Florida Supreme Court, U.S. Supreme Court, and we don't feel like it's any reason to the stay the proceedings at this time.
All right, I have a couple of questions for you, Ms. Peoples. I had received a copy of your petition for writ of certiorari to the 5th District Court of Appeal. One of the issues that you brought up is one that I'm just not recalling ever ruling on or ever having even discussed, and that was the number of peremptory challenges that each side would receive. I don't recall ever making a ruling that we were only going to utilize 6 peremptory challenges per side. In your petition, you allege that I made such ruling. So can you tell me, was that done, or was that?
Your Honor, when you reduce it from as charged, or reduce the number of jurors from 12 to 6, the number of peremptories are reduced also.
That's not correct. We're still entitled to 10.
Statute 913.08.
Yes, Your Honor, but I don't have the statutes or the writ before me.
Madam Clerk, if you'll pass this to Ms. Peoples, please. If your client is facing a life sentence, then he is still entitled to 10 peremptory challenges. So the court was always inclined to utilize 10 peremptory challenges per side. That never changed. So I want to make sure that that issue is cleared up.
Right, but the reasoning before the court, subsection B is 6, if it's not punishable by death or life. And because the court had argued that the defendant is no longer facing an offense punishable by death, that's
Or
why.
life, but he is facing a sentence punishable by life.
Right, but 10 is an application for the capital charge.
10 is an application. If life is an option, which it is, if it's punishable by life, then he's entitled to 10.
Yes.
He's going to get 10.
No, and I'm in agreement, but it's the way the court had presented the argument that, because as you can see on
did I ever say anything about peremptory challenges? If I did, I'd like, I don't recall ever saying that.
And I don't recall defense counsel making arguments about peremptories. I'm just saying that with the ruling as provided on the 20th, that the court had argued, in following the state's logic, that because he was not facing the death penalty, that he was facing a life sentence, that would reduce the peremptories down to 6. So I understand the
That's what
court's
the
position.
statute says, so as to that issue, I want to be very clear. We're going with 10. I
Yes,
assume the state
yes.
would be in agreement.
And that
with
was never, ever brought up, correct,
So
that is the
there will
law.
be 10 peremptory challenges per side. So we're all on the same page on that. As to your motion to continue, I have looked at the petition. I have again gone back and reviewed the case law. And again, the court relied on Walling v. State, which in this court's estimation is directly on point as to this matter. And it's the only DCA case that this court can rely upon. And I know that you had relied upon Johnson v. State, which was also a first DCA case, but that was distinguished from Walling. Actually, within the Johnson opinion, they talk about Walling. And so, at this point, the only way if the Fifth District Court of Appeal were to grant your petition, frankly, I don't fully understand why there would be an irreparable harm if he's entitled to a new trial. So I'm not sure if they're going to adopt it or address it as a petition, or if it's a matter that would come up later. But the bottom line is, in order for them to, they would have to certify conflict with Walling, which then means it would then have to go up to the Supreme Court. I would imagine, but the state would then appeal it. So then we're looking at extending this trial and not being able to conduct this trial for quite a long time. And I'm just not willing to do that.
I understand, but if the court looks at the timeline as presented, it's roughly 30 days.
Well,
But
That's
the
for
50
briefing, but
that's
that,
just for briefing.
That's correct, Your Honor, but the last time that these aren't issues that take years on end to resolve. I don't think it's a light thing that the 50CA has taken the writ and asked for a response and reply. And the state is correct, it was not filed as an emergency writ, and that would be an error on defense counsel. So the state's now identifying that there's an error in defense counsel's filing before the 50CA is not identifying it as an emergency writ, and not identifying that jury selection would be on the Monday. So rather than compound the error on counsel's work and pick a jury, I'm asking the court to stay the proceedings in light of what the 50CA is doing at this time with their review. Because the court has had it before you, the state has identified this, defense did not identify this as an emergency writ.
Regardless of that, there is no irreparable harm that would preclude this court from proceeding to trial next week. So I'm going to deny your motion to continue. We are going to proceed to jury selection on Monday morning. I need a statement of the case, so I have something to read to the jurors on Monday, so I know that you all will continue to work on that. Jury instructions, I want by 5 o'clock on Friday. If you have any proposed defense instructions, please make sure that I get a copy of those by 5 o'clock on Friday. All other matters of discovery are completed at this time.
Yes, Your Honor, we've received a redacted copy of the transcript from the state and one of the videos that they did want to play for the jury. I just wanted an opportunity to go over that one other time with the transcript with counsel, with my client.
Sure.
So we were able to play it in part, but because we're in chambers, we'll see if we can meet in person.
Okay.
and that, just since Your Honor asked specifically, there is one other probably filing I will make later today or tomorrow. Ms. Peoples verbally knows what it is. It's not gonna impact anything. Something that happened late that we had to react to, so it's nothing that's material to the case, but I obviously have to disclose it. She's aware of what it is.
Okay. Let's see if I can get her into that. All right, well, we will address any other matters that we need to Monday morning, but the plan is to be here by 8:30 on both sides, by 8:30, and to begin our jury selection. As I previously stated, we have jurors reporting that morning. We plan to bring 50 up to the courtroom, so you can create your maps of the courtroom, if you will. And we will be referring to the, as we previously talked about how we're going to refer to the jurors, and we'll go over all that on Monday morning. Okay?
Yes,
Any
sir.
other matters from the defense?
Not at this time.
Very well, we will, see you back here Monday morning. We'll go to recess, allow everyone to clear out, and I'll finish up some of the cases that we don't.
I'll let you know.
Court is in recess.
Rights being paid.